Welcome to the Consumer Finance Podcast. I'm Chris Willis, the co-leader of Troutman Pepper's Consumer Financial Services regulatory practice. And today we're going to be talking about a grab bag of interesting and emerging privacy-related issues that are of concern to the financial services industry with a special guest. But before we jump into that topic and I introduce our special guest, let me remind you to visit and subscribe to our blogs, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And don't forget about our other podcasts. We have lots of them. We have the FCRA Focus, all about credit reporting, Unauthorized Access, which is our privacy and data security podcast, the Crypto Exchange, about everything crypto, Payments Pros, which is all about the payments industry, and our newest podcast, Moving the Metal, all about the auto finance industry. And all those podcasts are available on all popular podcast platforms. And speaking of those platforms, if you like this podcast, let us know. Leave us a review on your podcast platform of choice and let us know how we're doing. And if you enjoy reading our blogs and listening to our podcasts, our mobile app is a great way to do it. Just go into your app store, either iOS or Android, and search for Troutman Pepper. There you'll find our mobile app that gives you reading access to all of our alerts and advisories and blogs, as well as listen access to all of our podcasts all in one place. It even has a great directory of all of our financial services lawyers, and you can call and email us from right inside the app. So please check it out. Now, as I said, today we're going to be talking about a variety of emerging and interesting privacy issues. And to do that, I'm joined by two guests. First, there's my partner, Phan, who's one of our privacy experts and also one of the hosts of our FCRA Focus podcast. And I'm very glad to have her here and glad to have been practicing with her for many years. But we also have a very special outside guest, which is Rami Haddad. Rami is the Deputy General Counsel for Regulatory Compliance, Data Privacy, and Litigation at PRA Group. And we're really glad that he's joining us here today. So Rami, welcome to the podcast, and thanks for being here.
Chris, it's always a pleasure to join you on the podcast.
Yes, thank you for having me. We really appreciate it.
So let's dive into some of the sort of interesting goings-on that are sort of privacy-related that have been happening, because I'd like to hear both of your take on what the areas of concern are. Let's start with state privacy laws, which seems like sort of an ever-proliferating group of laws, because there were a couple at first, and now I feel like there's more and more being enacted. Let's just talk basically about the scope of coverage of these laws. Do they even apply to financial institutions and financial services companies? Let's start with that.
The reality is that the Gramm-Leach-Bliley Act, which is the federal financial privacy law, is incredibly useful in that many of the states have recognized if there is an existing privacy regime that is protecting consumers in this space, then there's no need to add additional privacy requirements on those entities. So for many financial institutions across the vast majority of these states, there is a wholesale entity level exemption for financial institutions that are subject to the GLBA. Now, there are a couple of states that have nuances with regard to the scope of the GLBA exemption in that they are limited to a data level exemption. That's what they're called, such that the exemption only attaches to the data to the extent it's being collected, used, stored, or otherwise disclosed in ways that are otherwise regulated by the GLBA. Outside of that, you're going to still have to comply with the state privacy law. And typically that comes into play for things like marketing activity. And there's really only 3 states that financial institutions have to worry about. It's California, Oregon, and Minnesota. But I know Rami has some thoughts about states like Oregon, where the threshold might not even be reached for many financial institutions.
Rami, go ahead. I'd love to hear what you think about that.
Thanks, Chris. Yeah, Kim is absolutely correct. We've seen a proliferation of enactments in the state privacy legislation. We have 19 states to date, 3 that don't have the wholesale GLBA exemption at the entity level, California, Oregon, and Minnesota. Minnesota is interesting. So the question is always the scope, right? Does it apply? And if it's not an entity level exemption and it's a data level exemption, then the question becomes, well, what do we do with that? Right? What data is non-GLBA that would be subject to the rule that would otherwise be required for us to comply with that? And so, interestingly enough, unlike California, Oregon and Minnesota don't have a revenue threshold, right? So the question becomes as to whether or not you control or process the personal data of 100,000 or more consumers in that state. And then that question in turn turns on whether or not the data is outside of GLBA, right? Is it sold, processed, or disclosed pursuant to GLBA? And if it isn't, so the question is, what data is that? So if all the data that you're processing is subject to GLBA, then what's left? Some of the questions that could come about from that is, well, the people visiting our website that don't log into our website potentially, right? And that we don't know our consumers and therefore subject to GLBA, or is that personal data that we control or process. So the scope is incredibly important. And how you get there, that's the analysis that needs to be done at any level. And I'll turn it back to Kim, see if she has any thoughts on the threshold and the scoping.
Yeah, for California specifically, most companies are going to get pulled in because California is the only state that really has a revenue threshold, right? If you have revenue of $25 million or more worldwide, it's not specific to your revenue in California, and you have information about even one California resident, then you're going to be required to comply with all of the bells and whistles that come with the CCPA. But Rami, you raise a great point. Oregon could easily just be scoped out because really, how much business is anyone really doing in Oregon? if you have 100,000 or more consumers in Oregon, certainly you would still need to comply. But that's an important threshold question to ask yourself. But even if you're not, does it make sense to comply with Oregon regardless and have a comprehensive privacy program that is uniform across the country? And I think as more and more states enact comprehensive privacy law, it becomes more reasonable for a company to just have a wholesale privacy enterprise-wide program rather than trying to build out nuanced programs for each individual state.
I totally agree. So that gets into the question of that probably every person or every in-house privacy attorney, if you have them, or in-house counsel, is grappling with across the patchwork of legislation that's come out of the privacy in states, which is, okay, how do we comply with this piecemeal legislation? How do we comply with all these requirements? I mean, take Minnesota, for example. In Minnesota, there's a data privacy protection assessment requirement. So if you're engaged in certain processing activities, of course, which is unlike other states. So then the question becomes, well, if we scope out a comprehensive framework, do we then not need to add all the other nuances? And how do we do that? How do we layer new laws on top of the existing laws that we've already complied with as these new laws come out? So I guess that a primary analysis is, well, does it apply? And if it does, what else do we need to do that we haven't done already? And how do we go about that? How do we layer the additional obligations when new laws come out?
So, Chris, as you can see, you've opened a can of worms on that one. There's no single approach, I guess, that has really emerged on how businesses want to approach this. It is still a very new, right? California's CCPA only came out in 2018. And as you noted, we are now seeing states enact these at a much faster pace. We're up to 20 now. So how companies are going to address this, it's still very much an open question.
Yes. And Kim, of course, we love a good can of worms here on the Consumer Finance Podcast. So thank you for noting that. Let me shift gears with the two of you for a minute and talk about artificial intelligence. Now, this is one of the most popular things for the media to like to talk about, and politicians like to talk about it, and regulators talk about it. But recently, 3 months ago, Colorado became the first state to enact AI legislation, which I want to talk about in a minute. But let's first back up one more step on the state privacy laws. Some of these state privacy laws, the 20 that you mentioned, Kim, do address things like profiling and automation. Is that AI, or is that something we should think of separately under these privacy statutes?
No, the problem is that there's no great definition right now of what should or should not be considered artificial intelligence. Colorado, the state that we're going to talk about in a little bit more detail, their definition of AI was so controversial. When they were enacting this legislation, they actually had to amend the bill during the legislative process to clarify that when we talk about artificial intelligence, we do not mean calculators. So your TI-85 graphing calculator back from high school, don't worry, it is not artificial intelligence. But it raises the issue that if you have to clarify that calculators are not intended to be your definition of artificial intelligence, maybe your definition is too broad. And so we're seeing that there's this struggle, the idea of our basic algorithms that the industry has been using for years. Is that artificial intelligence? Is the type of credit profiles that consumer reporting agencies have been conducting over the last 50 years under the FCRA, is that going to be considered artificial intelligence? There's a lot of concern about the overlap of what they are pulling into these artificial intelligence proposals with existing laws like GLBA, FCRA, and others that I don't think have been resolved yet in any of the proposals so far, and certainly not in the Colorado Act.
I would agree with Kim. I think that's one of the most difficult aspects of what legislators are trying to grapple with, which is how do you define AI, right? The words artificial intelligence have become ubiquitous since ChatGPT came online, right? And now it's become an issue of, well, what is and what isn't? And how broad do we define it? I mean, the EU UI Act, which came into effect, which Colorado borrows heavily from, very broad definitions of what AI could be. But yet we do see those little exemptions about, well, it's not your graphic calculator. Well, if you had to go out of your way to say that, then perhaps it is too broad. And so what does that encapsulate? And that's the difficulty. And I think if on the state side, California, Virginia, Colorado, Connecticut address automated decision making. And if you look at so California hasn't enacted it yet. The regulations are still pending on ADM or automated decision making. But if you look at the proposed draft regulation on how that's defined, I would say it does. It does include artificial intelligence type algorithms, machine learning, and you could easily back into AI through these privacy regulations. And so we have to be careful because then you also have duplicative laws that are coming out.
Yeah, the state privacy laws are not great about taking a uniform approach toward this.
Correct.
Because we know that the California Privacy Protection Agency, the first and only state agency that's devoted entirely to privacy, California loves reminding everybody about that. They've been working on AI regulations. And while they have started a formal rulemaking process this summer, they're nowhere close to having actual rules. They have draft rules that they've released for public review, but it's by no means what's going to be final. And then you have the other states like Oregon and Minnesota that address things like profiling, right? And some of those requirements are quite onerous in the state privacy laws with regard to having to disclose to consumers that profiling is even occurring, what information is being used to feed that profile, giving consumers rights to access the data that was used to make a decision in a particular profiling case, and requiring a reevaluation of the decision used in that profiling if there are any corrections that needed to be made to the underlying personal information that led to that decision. And all of that is not even close to what the Colorado AI Act is, but we're already seeing that even in these disparate state privacy laws, we're seeing very strange variations come up that could touch on artificial intelligence.
All right, we've talked a little bit about the Colorado law, but I want to just jump straight into it and ask both of you a question. I've read the law and I've heard all about it. It's the first law of its kind passed by any state in the country, but it might serve as the model or impetus for other states to do something similar. Tell the audience a little bit about the Colorado AI law, what it requires and who it covers, and specifically, does it apply to financial services companies?
Sure, I could start. Absolutely applies to financial services companies. It actually applies to it defines it as person, but then person is defined in the act, right? So it's corporation, business, partnership, so on. So if you're doing business in Colorado and you develop or deploy what's defined as high-risk AI systems, right, you're going to be covered under the law. And so then the question becomes from there, if you're covered, are you deploying or developing? Are you a deployer or a developer? There's different obligations. And are you involved in doing so with respect to high-risk AI system as that's defined under the law? Because the law is really aimed at two things. It's automated decision-making, as we said, but really targeted at prohibiting algorithmic discrimination. That's one of the real catalysts behind the law was to prohibit that. And we've seen regulatory bulletins and commentary about that from the CFPB and so forth about the laws apply to you and they're agnostic as to what methods you use to develop your models, right? You still have to comply with the law at the end of the day. It doesn't matter if you use AI to do it or not. The real issue comes down to the way the law is framed, both in the definition of, like we just talked about, which is AI system, which is broad, but also the fact that it has to be used or deployed as a substantial factor in making a consequential decision. Now we get into two more definitions, right? What is the substantial factor, and is it a consequential decision? That's really where I think the analysis has to come in, whether it's, if you think about the consequential decision, it's defined as what has a material, legal, or similarly significant effect on the provision or denial or the cost or terms. So those are the main things, right? Provision or denial, cost or terms, but then it goes on to talk about in what context, right? It's education, enrollment, employment, financial or lending, and essential government services, healthcare, housing, insurance, or legal. And none of those are defined, I think, other than, I believe, healthcare. And so what is financial? What is lending in our case? That's pretty broad. And so if it's not defined and you're engaged in what could be construed as financial or lending, and you deploy this high risk AI, and it has a substantial factor in playing provision or denial of cost or terms, you're going to be in scope for the law. And it is pretty onerous. There's a lot of requirements, many of which are the disclosure requirements that you have to provide. Also, first of their kind, which is you have to tell the consumer that you're using this high risk AI system.
Yeah, and let's talk a little bit more about the requirements of the Colorado statute. You mentioned, Rami, the disclosure requirements, and my recollection is that there are disclosure requirements by a developer to a deployer. So the deployer can then make disclosures both generally to the public as well as to specific consumers who are impacted by one of these high-risk decisions, as you've just defined it in the Act. So there's that. But then there's also another sort of more substantive directive in the Act about bias and discrimination. Kim, do you want to tell me about that?
The layers of disclosure that are required by the Colorado Act are where I think is most of the burden, right? So you have developers of AI, you have the deployers of AI, you have the subjects of AI, and then you have the Attorney General who is mixed up in all of this, right? So developers have to provide disclosures to deployers. Deployers have to provide disclosures to consumers. Developers and deployers have to provide information to the Attorney General. So if the Attorney General wants to step in, the Attorney General has the information needed to do so. And all of this, I think I went through the law and there was like 10 different notices or disclosures to different entities within different steps of the AI decision-making process. Is really quite burdensome. And while there is some language that says you don't have to reveal trade secret information, but if you're explaining how your AI works, here's the data sets that are the basis for it. Here's the reasoning and logic behind how the AI makes its decision making. Here's the results that you can expect, right? If you're laying all of that out on something that you've internally developed, like how is that not trade secret information that they're asking you to hand over into the public space with regard to what you're trying to do? So I find it very, very document heavy, the obligations that are being laid out by the Colorado AI Act that I think won't be beneficial to industry. And I don't know that it will add additional protections to consumers. So I don't know what it's actually achieving, but again, I think, as you noted, Chris, could potentially be the framework that other states follow, which I think is very troubling.
And Kim, like these disclosure requirements to consumers, like there are these general public disclosures of like, I'm using an AI decision-making tool and here's how it works, like you were just talking about. But there's also this requirement of disclosure to a specific consumer whose transaction is impacted by the use of AI. And notably, like in the financial services industry, we're used to adverse action notices. Like we give somebody a notice if they're like declined for credit or they don't get the terms that they applied for. But if we say yes to them, we don't give them a disclosure. We just say yes. This statute seems to impose that notification obligation, whether the answer is yes or no, right?
That's correct. So you have a front-end notification to the consumer saying, we are planning to use AI, and here's all the information about the AI we might use. And then there's a back-end disclosure about, we did actually use AI, and here's the decision and all the reasoning that went into that decision, so that if you want to appeal our decision, we can. And the need to impose a process by which a consumer can then appeal and challenge an AI decision, all of the benefits of AI, the efficiency, the efficacy, all that goes away if you didn't have to revert back to a whole process anyway. And it would be required regardless of the result. So it could be a positive result. Yes, you get credit. It could be a negative result. No, you don't get credit. But either way, you have the disclosure obligations. It's not contingent on what the actual result is.
Yeah. And then just one last thing I want to highlight for the audience about the Colorado statute is there's this very undefined duty in the statute that people who develop, and I think it's just developers, are required to take steps to avoid or mitigate algorithmic bias or discrimination by the use of the technology. And of course, like I'm a fair lending lawyer, so that is interesting to me in that, what does it mean? Does it mean I'm not going to violate the Equal Credit Opportunity Act and I'm going to apply my same old fair lending testing like I've been doing for many years? Or is there room for somebody to argue that, no, this requires something different? than compliance with like our specific non-discrimination statute. Does either of you have a take on that?
I think with respect to discrimination, I think we've seen some of the regulators come out and talk about that when AI started to come on the scene and become more, like I said, prevalent and ubiquitous, right, in terms of that. With respect to Colorado, I don't know that it's going to be any different than what's going to be required, generally speaking, about with what's happening on preventing discrimination in fair lending that we've seen bulletins from other agencies. And in the sense that if you haven't already, you should start working immediately on an AI governance program internally. You should base it on a certain standard that is recognized, such as NIST potentially or ISO. And you need to have that documented. And it needs to be based on some of the overarching tenets like fairness and ethics and transparency and privacy. Obviously, if you're deploying certain models versus others, traditional regression models versus new machine learning or black box models, you need to really work with counsel or on debiasing the model to the extent you can, right? How do you do that? How do you debias the model to really prevent sort of what the general discrimination that could arise under these laws, under the new laws, if others copy what Colorado has enacted?
Okay. Well, I think we've talked enough about the Colorado statute, although we could probably enjoy ourselves doing that for a little longer. But there's a couple more topics I'd like to ask the two of you about. Let's move to the subject of online tracking technologies. And so let me ask the two of you to address first, in private litigation, how are plaintiffs effectively applying CIPA and other state surveillance laws to online tracking technologies, cookies and pixels and things like that?
So this type of litigation is one of my little pet peeves. I do not understand how this type of litigation continues. It seems illogical to me that you can apply what are essentially very archaic laws to modern technology. For example, some of the wiretapping laws that were intended for back when people had a physical wire between their landline phone to another third party and someone could listen in on their calls. Well, it's the internet, so there is no wire that is being tapped. So how does that even apply? And even in the cases where you could argue that there is a physical connection to the internet, an Ethernet cord or something along those lines, most of the entities that are being alleged as the third parties listening into these conversations are actually third-party service providers, agents of the financial institution, right? Google Analytics or one of the other session replay companies that are hired by the financial institution to listen into these communications. And that's what the argument that when someone browses your internet and they click on different things, that's a communication as to what they're interested in. And it becomes a conversation. So anyone listening in on that conversation is treated as a third party, which is fine. But again, if they're the agent of the bank or other financial institution, it's for the bank's benefit. So these arguments drive me crazy, but we are seeing that they are having some success, mainly in California, but we're seeing this spread across the country, Florida, New York, Pennsylvania, even others. And they are at least surviving motions to dismiss. Many of these cases aren't making it all the way through. They settle. And it would be great to have some more case law that illuminates on how these laws are applicable today, but we're still very early in this process. This litigation is only a couple years old.
So Rami, from the in-house perspective, should companies be doing things like conducting cookie audits or taking other proactive measures with respect to these kinds of tracking technologies?
Absolutely. I agree with Kim. It's very frustrating to see antiquated laws being weaponized in this manner. I mean, we've seen on the federal level, you see the Electronic Communications Privacy Act, but most frustrating, I think we've seen some of the litigation that has kind of died down recently with respect to the Video Privacy Protection Act, VPPA, which was, if you look at the law, it was back in the 80s when I think some judge's rental records at a video store were disclosed. And
Robert Bork,
thank you. Yeah, it was. I mean, we're talking about rental records at a video store from the 80s. And here we're seeing it materialize in today's world and the digital age. I mean, the Boston Globe case was the great case, right? So the Metapixel tracked the user's viewership of the video on the website. So akin to a rental record. So now your viewership of the video was then tracked and therefore without their consent. And so in any event, the VPPA has kind of died down, but the SEPA and other states that have similar sort of wiretapping laws, those are concerning because we've seen inconsistent application by the courts and decisions that are come out, particularly in California. The lawsuit's alleging that all these mechanisms that are dropped on the website, cookies, pixels, web beacons, that are akin to pen registers or trap and trace devices. But if you are in-house and you have a marketing or strategy team, or whoever's in charge of your web development or marketing, strongly recommend that they work closely with legal and compliance. As the last thing you want to avoid is some marketing or web development potentially dropping a tracking mechanism or a beacon or a pixel on a website and you don't know about it, or inadvertently at least, and somehow you fall trapped to one of these SEPA claims or VPPA claims inadvertently because you didn't know. And so you should scan the website on a regular basis for sure.
Okay, thanks for that. Let me hit one more topic with the two of you before we wrap up, and that's just sort of round up where we are on cybersecurity. So I know, Kim, that the Federal Trade Commission recently updated the Gramm-Leach-Bliley Act safeguards rule. Are there any highlights or pain points relating to that updated rule that you'd like to share with the audience?
Yeah, it actually was probably a long time in coming and a bit overdue. The GLBA safeguards rule hadn't been updated in 20 years. So it probably was time, but I think the FTC has implemented a very onerous process in ways that it probably didn't need to. It cribbed pretty heavily from the New York Department of Financial Services cybersecurity regulations and the National Association of Insurance Commissioners model law. And it picked bits and pieces from both of those and have put into place a process that is very prescriptive, right? The old safeguards rule was very much flexible in approach, like do what makes sense for your organization based on the types of products that you make available to consumers and the number and type of consumers whose data you have, right? So it's very much built around the idea that whatever your risks are, you would appropriately address them. Now, it's very much, you have to have encryption. You have to have multi-factor authentication. You have to have a data inventory. You have to have a disposal policy that's being regularly updated. You have to have change management and training, right? It is very, very much a checklist of the things they're expecting you to have. And for certain financial institutions, that can be problematic. I think a major pain point we're seeing for many financial institutions that have to now comply with this is certainly with regard to legacy systems, older systems that it's harder to update for some of these more modern expectations. And while many companies were already working on shifting data away from legacy systems to more modern systems, it can take a long time, right? That's the reality of the technology. And being able to do so on the FTC's timeline can be challenging.
Rami, what's your perspective on this? Coming from in-house, Kim talked about some of the pain points on implementation. What's your view on that?
Yeah, absolutely. I think we went and not without probably good reason, right? And so from the FTC standpoint, it's probably a long time coming. And the fact that the older version of the safeguards rule was kind of, suffice to say, kind of squishy, right? It was kind of or to do what makes sense, but very vague general language, right? Technical, administrative, procedural safeguards, and then you're left up to your own devices. Whereas now we have more of a blueprint, right? You need to follow this blueprint, encryption at rest, transit, so on and so forth. I think the modern consumer is going to get accustomed to that, and I think they already have. And if you're dealing with a financial institution as a consumer, you go to a bank, you're accustomed to getting MFA. You're accustomed to getting that security email or that text message. And probably not without good reason. I mean, threat actors have become more sophisticated. If you think back about how we got here in the first place, the reason for the breach laws that started out at the state level, going into the conversation around privacy and why we have not privacy laws, you look back at a history of data breaches, significant ones that have happened over time and that are concerning and that sort of reduce the trust that people have in financial institutions and other institutions about safeguarding their personal information. So yes, they were onerous, I would agree. There was some flexibility left in the rule about how to enact some of these, especially with respect to legacy systems. But if you're trying to comply with these, there's going to be cost of compliance, and that's just cost of doing business.
The one other thing I wanted to point out about the GLBA safeguards rule is the new update, the latest final rule that was announced earlier this year with regard to data breach notification to the FTC. I've found increasingly that companies find it very challenging, the reality that breach notification requirement is triggered by any non-public personal information being subject to unauthorized access if it impacts over 500 consumers or customers. The reality is non-public personal information is an incredibly broad term, right? It applies to pretty much everything that is gathered with regard to the provision of financial product or service. So I have clients who maybe something was just mismailed. So it was only the name and address alone that was disclosed, but that is non-public personal information. So they're forced to send a notification to the FTC about this. Or another client that, again, the only thing that was exposed was an email address. Nothing sensitive, nothing that could lead to identity theft or fraud or anything like that, email address alone. And they were, under the new requirement, forced to send a notification to the FTC. So I would consider that particular challenge right now because I don't know what the FTC is ultimately doing with all of these. They have said they're going to make these all publicly available on a database on the FTC site, but that's not live yet. So we don't know what that will look like when it does go live. But certainly, I think this is leading to over notification of the FTC of incidents that really are not any kind of risk to anybody.
Yeah, I would agree with Kim. I would want to add one quick thing, is that it's extremely broad. The information scope is much broader than state breach laws, which narrowly define personal information. The kicker, I think, is the fact that there is no qualification for good faith acquisition or likelihood of misuse under state breach laws. So any acquisition of any NPI within scope is arguably going to trigger the rule if it involves 500 or more consumers.
And not just acquisition, right? It says if it was merely access, but you can't prove there was no acquisition, you still have to treat it as acquisition.
Agree. And one other thing, so this is a new one, but let's not forget, so you have the state breach laws, now you have the FTC notification event rule, but then you also have the SEC cyber disclosure rule. So if you're a publicly traded financial institution, at any given time you have an incident, your analysis now has become at a state level and at a federal level, both from an FTC and an SEC. So there's quite a bit of work to do if you should ever have an incident.
Well, Rami, you mentioned the SEC rules, and that's a good segue to the last question I wanted to ask the two of you, which was there was a recent SEC enforcement case relating to cybersecurity. And I wondered if the two of you had any comments on sort of the implications or takeaways from that you'd like to share with the audience.
This is another case, Chris, where we're seeing the application of long-standing principles and standards here, in this case, SEC accounting requirements, being applied to situations that I don't think were contemplated at the time. Basically, with regard to this case, this was against SolarWinds, involving the broad, expanding incident that involved them and many of their clients. They applied basic accounting principles to the disclosure obligations with regard to this cybersecurity incident. And it doesn't seem like it's a great fit, but not only did they bring these allegations against the company, but also brought charges personally against the Chief Information Security Officer, the CISO, with regard to his role in these disclosures. So should companies be nervous? Absolutely. Should individuals at these companies with any of these cybersecurity obligations also be nervous? Absolutely.
Yeah, I agree. Now, it's not the first time a federal agency has gone after individuals in that capacity, but it's the first time the SEC has done so. And it's the first time that they've actually leveled intentional fraud charges in a cybersecurity disclosure case. From an in-house perspective, yes, if you're a CISO at an in-house position right now, I'd be on alert to about this case and about what the charges the SEC has brought. But there's also lessons learned from it. If you're a CISO or in-house, what do you learn from it? It's the disclosure, transparency, right? Individuals may be charged, but it's clear, specific, broad-based disclosures that the SEC is concerned with. And it's public disclosures. They're going to look at that. They're going to take that into consideration, statements on the website and so forth. But it parlays into the SEC cyber disclosure rule, which requires you, if you're publicly traded, to disclose those on an annual basis, right? What is your governance structure from a cybersecurity perspective?
Okay. Well, this has been a really great ranging discussion over a lot of very hot topics in privacy and data security and even AI. So, Rami, thank you for being here with us today. And Kim, of course, thank you as always for joining me here on the podcast. And of course, thanks to our listeners too for tuning into today's episode. Don't forget to visit and subscribe to our blogs, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And while you're at it, why not head on over to troutman.com and add yourself to our Consumer Financial Services email list? That way we can send you copies of our alerts and advisories and invitations to our industry-only webinars that we conduct occasionally. And as I said at the top of the program, check out our handy mobile app. It's available for both iOS and Android. Just look for Troutman Pepper in your app store and take a look. And of course, stay tuned for a great new episode of this podcast every Thursday afternoon. Thank you all for listening.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.